Hi, this is Brian Bieron with PlatformEconomyInsights.com, and today's briefing takes us out to the state of California. We're not just looking at California a little more than other states because it's the biggest state or because most digital companies tend to either have customers there or they have people there, but it's also because California, more often than not, ends up being a leader when it comes to digital and economic regulation, at least in the United States. And so there are two big state issues, which if you've been following what we do here at PlatformEconomyInsights.com, you know that there are two big issues that we've been tracking. One of them is legislation that would put a framework around the gig economy work rules. This follows up on the California Supreme Court's Dynamex decision. The legislation is AB 5, and we've been talking about that quite a bit. Today's topic, though, is the other big issue in California at the state level that digital businesses are focused on, and that would be the CCPA, the California Consumer Protection Act, which is a state law that was enacted in mid-2018. It goes into effect on January 1, 2020. So we're less than a half a year away. Now, the CCPA was enacted around the same time as the European General Data Protection Act, the GDPR, General Data Protection Regulation, was going into effect, and really has been seen by many as kind of a United States counterpart to the GDPR. And if you follow privacy policy and regulation globally, you know how impactful the GDPR has been, not just in Europe, but honestly by technology companies if they have customers in Europe. And even more importantly, it's really been seen as a regulatory sort of leader in terms of how many countries are starting to look at modifying their privacy and data regulations, in part so that their domestic digital companies can take part in the European marketplace. So the GDPR is a big deal. California enacted the CCPA around the same time, and as we've been going month after month, heading into the law going into effect, there have been a number of efforts to try to amend the law because it was not really clear in terms of the way that digital companies needed to deal with data. So, big picture, the CCPA attempts to give users more control over whether their data could be sold. But of course, as you know, the concept of selling data is not entirely clear as to what it means, because in many cases, businesses make money because they're effectively able to use data, but they're not actually selling the data. They're simply becoming more efficient at providing services because they have data on users, and in fact, they know how to glean insights from the data. So there's going to be significant work that needs to be done to actually flesh out from a legal and regulatory perspective what selling data really means. But number one, you've got issues that are open regarding to what selling data means. You also have a proposed mandate to allow for something called data portability. And this, of course, will mean that users theoretically have an ability to take their data from a business and move it somewhere else, which raises a huge number of issues regarding things such as who really owns what data is really a user's data as opposed to data that, let's say, is gathered from users with users, but also from other parties or created, in fact, by the platform. And then there are many privacy issues that are brought into the situation when, for example, a person's data also involves other people. And do those people have a right to not have their data or data about them or that includes them transferred somewhere else? These are all open questions. Well, the reason why I'm doing this briefing today is that we are running up to what is supposed to be the end of the legislative session in California. That will be the last opportunity, it is said, to be able to amend the CCPA. And so Friday, September 13, is said to be the last day that amendments can be enacted by the legislature, which would impact the legislation for when it goes into effect in January. And there were a number of news reports and other stories about an effort by digital companies, in particular the largest digital platform business, to try to amend the law before you get to that important Friday the 13th deadline. Now, whether or not any meaningful changes will happen in the coming few days is an open question. I tend to suspect that the answer is no, but we'll see. There's a pretty strong community, both politically and inside the California legislature, who are really committed to doing what they believe defends a strong privacy law. So we'll see if any big changes are enacted. Another thing that's worth noting is that when the CCPA was enacted, many thought that this would be the spur that would push for the U.S. Congress to enact a federal privacy law that would preempt states. The concern is that if states move forward one state at a time on different kinds of privacy and data mandate laws, that it would become increasingly hard for any business, in particular smaller and mid-sized businesses, but even large businesses, to be able to actually comply with all of them. So the thought was that maybe this would give new energy to those who would want to see a federal privacy and data law. Now, that has not ended up happening. So the new Congress came into office back in January of this year, and again, in particular because you had a number of technology and internet trade groups saying much more positive things than in the past about a federal privacy law. The thought was that maybe this would create the conditions for both bipartisan support, but also support between industry and other consumer groups for a federal privacy bill. We have not seen that. And in fact, in many ways, I think the strength from the privacy advocate perspective of the California law is potentially undermined the prospect for a deal at the federal level. Because the number one thing that the technology community in particular would be looking for would in fact be preemption from state laws and the creation of a single federal standard. But because the California law is seen as such a big step forward on the privacy law front in the U.S., preemption of state laws, preemption, for example, of the California law, immediately became something that I think privacy advocates were very wary of. And so, honestly, bipartisanship on this topic has not happened. And so we then are back to looking at what's happening in the states, and in particular, I think all eyes on California. So, to wrap up, we're looking forward to the rest of this week to see if in fact there will be any major amendments, any substantive amendments to the CCPA implementing bill. We'll watch that. We'll see how that plays out both this week and in the coming months. And then, honestly, we will be keeping an eye on both how companies are preparing for January 1 and implementation, but also be thinking about the kind of legal issues that are going to be probably fleshed out in courts as the law goes into effect and there are challenges and other implementing kind of regulatory situations occurring. And then finally, how do both other states react and whether or not the CCPA going into effect actually does kickstart something at the congressional level, at the federal level, to potentially create a new federal standard. We'll see. Again, this is Brian Bieron with PlatformEconomyInsights.com. In this case, looking at the issue of the California Consumer Protection Act. Until our next briefing, have a good day.